In our last conversation, we spoke about detention, and earlier we had talked about immigration court proceedings. What is the form of remedy called voluntary departure?
Voluntary departure is often utilized. It's actually considered a benefit that's granted to an individual by an immigration judge. And what it basically, if you're not in detention, what it allows you to do is say, you know what, I don't have a form of relief. However, I'm asking to leave voluntarily at no expense to the government. And you have up until 120 days. It's up to the judge how much they grant, and typically the longer you've been here, the more ties you have, the more likely you are to get the full statutory limit of 120 days. Basically, you have to show that you qualify, which means you don't have any disqualifying criminal history. You have to show that you are ready and willing to pay for your own travel. You have a valid passport, and you have to basically give up all your other rights to any sort of request for form of relief, and there's no appeal from that decision once you take it. Lastly, there is a discretionary component. So even if you don't have disqualifying factors that would kick you out, legally speaking, the judge still has the right to say, you know what, I don't want to give you voluntary departure. The benefit to taking voluntary departure for a non-detained person, number one, you get to leave on your own without being detained. Number two, in many cases, if you comply with your voluntary departure order, you are able to return to the United States under some other form of some other program, whether it's through a U.S. citizen sponsoring you or something, something else that may be a benefit to you down the road. In detention, voluntary departure is given as well. However, they do not let you out on a bond. It's called voluntary departure with safeguards. And basically what that does is, again, you're asking for a benefit even though you're in detention and you're not going to get out. By saving the government the cost of your removal and taking the voluntary departure, as long as your family buys your ticket or whoever, and you're gone within those 30 days, they treat it like a regular voluntary departure order, where if you want to come back through another program, whether it's through a child sponsoring you who's over 21, it makes it a lot easier for you to be able to return to the United States later.
Let's turn to the topic of expedited removal. And I have a slide here. This is from the ACLU, and it is showing a border of the United States, and the highlighted portion is 100 miles from each land border. Now, what is the significance of this term, expedited removal?
Well, expedited removal is basically immediate removal from the United States. You're not admitted or paroled for any reason. Typically, the reason it was enacted by Congress was because of the high levels of illegal immigration, and they wanted to take away the sort of review process for people who are caught in the act of entering the United States. If someone's entering the United States and they're considered an arriving alien up until the end of this border, then CBP, Customs and Border, is it Patrol or Protection? Well, in any case, a CBP officer can pick them up and just immediately return them to the point of entry. Now, they do not have to issue an expedited removal order to do this. There are other methods of returning people to their countries at the border as well. Some are voluntary returns, which is a process through which they don't actually have a formal proceeding. When you actually get expedited removal order, they actually have to do a whole list of questions that they ask you, and actually it's a little mini proceeding, and then they elect to go ahead and issue an order against you. The consequences of an expedited removal order is that you cannot come back to the United States for 5 years. You cannot get any benefit from the United States for at least 5 years. Voluntary return, where a CBP officer may not exercise his or her right to issue the expedited removal order, does not have as severe consequences. Now, you can challenge an expedited removal order. There are other grounds besides just illegal entry that you can be given expedited removal orders. That can be if you are charged with fraud, or if you are attempting to enter the United States on some sort of a fake a passport or visa. So there are other ways that you can be given an expedited removal order, but typically it's people crossing the border.
The significance then of the 100 miles of this radius, and the ACLU calls it the constitutional free zone, or
Right.
the Constitution doesn't apply there. And they mean a couple of things, right? One is that this expedited removal process can be exercised up to 100 miles within the border. And so someone who has surreptitiously crossed the border and the agent believes that this person has been in the country less than 2 weeks, I believe it is, then they can be subject to expedited removal, which is there's no hearing before an immigration court.
That's right. If you're subjected to expedited removal based upon the fact that you're categorized as what's called an arriving alien, and you are immediately categorized as such within that 100-mile border, you do not have a lot of rights. If, for example, you're detained, you're not eligible for a bond. You are subject to expedited removal should they decide to exercise that right, and you have very limited forms of relief available to you. If, however, you make it beyond that point and you actually enter the United States for purposes of asking, being able to ask for any sort of defense from removal should you be placed in removal, then you're treated differently. You're no longer an arriving alien, but you are an alien present in the United States, not admitted or paroled. To go back to your pie chart, someone's placed in removal proceedings based upon not being admitted or paroled and being in the country illegally.
Entry without inspection
Correct.
being one.
Yes.
Yeah.
And then at that point, they can ask for whatever forms of relief they have available to them. More than likely, if this is their first time to the United States and they have no other claims, there probably isn't much relief from removal. However, it does put them in a different legal standing.
There's also a statute of Congress that says immigration officials can conduct warrantless searches also within this 100-mile zone. So that's another aspect of how the Constitution applies differently based on geography. And here's one of the issues that has received some attention recently is to the extent that the border officials are more active in this 100-mile zone, then anyone living or traveling in that area, if they are U.S. citizens, better be able to prove it.
That's right.
Right? And so there have actually been accidental deportations of U.S., not accidental, they're on purpose, but they're mistaken.
Right.
Deportations of U.S. citizens for exactly this reason. They get caught up in a system where they don't have representation. They can be pretty much summarily deported under expedited removal simply because the official did not believe their story that they were a U.S. citizen.
In other cases, I mean, just on a lesser level, I mean, routinely U.S. citizens who may have the color of my skin or look like they may be from a Central American country, those are typically the people who are targeted. They routinely ask for paperwork to prove that they are, here legally, and so there have been some civil liberties violations as well, I think, towards the U.S. citizens who are sort of more in those border states. And obviously, through that state legislation that we've seen that went around the country, including here in Georgia, there was fear that we would be facing those same types of issues here. And one of the arguments was that these states, like Arizona and New Mexico, they have special reasons for having to do this, whereas Georgia is so far removed from there that we're not in the same situation. These are just different arguments that people made. But yeah, so aside from accidentally removing U.S. citizens, I think that U.S. citizens were, in my opinion, unfairly harassed, depending on how they looked in those same areas.
We have one more slide that I would like for us to consider. This is put out by a university, and it's a warning to their students, their scholars, and employees who are not U.S. citizens about what documents to carry. And this is, of course, within the 100 miles in which warrantless searches and other encounters. But it's basically a carry these documents.
I often wonder how little kids, for example, you're 14 years old, you're outside playing, I wonder often how are they able to prove that they're here legally or show any documentation, because I know as a 14-year-old I didn't have any. That I knew of anyway. I'm sure my mom had a social security card for me somewhere, but it's not something I carried around as a 14-year-old. So it is interesting that even kids have to be subjected to that.
Well, Amna, thank you very much. It's been helpful to have you with your assistance in the course.
Well, thank you for having me. It's been fun.
The preceding program is copyrighted by Emory University.